Good afternoon, welcome. I'm Jeremy Talmadge, the Associate Dean for Faculty Development here at the Law School. It is my great pleasure to introduce Brian Leiter, who is the Carl Llewellyn Professor of Jurisprudence and the Director of the Center for Law, Philosophy, and Human Values at the University of Chicago Law School. Professor Leiter earned both his JD and his PhD from the University of Michigan. His PhD is in philosophy, and I don't think he's going to have any Nietzsche references today, but he is an expert on Friedrich Nietzsche. I have one disappointed audience member. You might want to throw in a reference. But he's primarily, and he got his BA from Princeton. He's primarily known in our circles as one of the leading authorities on the tradition of American legal realism, which he's going to be talking about for us today. I also want to put in a brief plug for his book, which is just out from Princeton University Press. It's called Why Tolerate Religion, and it just came out last month. A number of us are going to be talking about it over lunch tomorrow over in the Christopher Center. If you're interested in joining us, let me know and I'll give you more details. But fascinating book, asking fundamentally, why does religion have a special privileged status different from other forms of conviction or conscience? Why does our legal system and other legal systems carve out special exemptions for religious belief? So, but today, Professor Leiter is going to talk about legal realisms, old and new. Professor Leiter.
Thanks very much. Thanks for giving me the honor of giving this year's Seegers lecture. It's very nice to be here. There's a version of this paper that is online at SSRN. Jeremy tells me he may have sent it around to some of you. So if you are looking at that version, you are going to get confused because that version is a good bit shorter than this version. So there's a lot of different material here, but the talk itself should run about 40 minutes, which will certainly leave us some time for questions and discussion. So legal realism, whatever exactly it is, now has sufficient prestige that scholars compete to claim the mantle of the realist program, whatever exactly that is, and I'll come back to that. Not all scholars do so, to be sure, but many from many different jurisdictions and disciplinary backgrounds do, as the international conference I participated in last spring on New Frontiers of Legal Realism at the University of Copenhagen in Denmark certainly attested. Scholars from Sweden, Denmark, the United States, Canada, Britain, Romania, France, and South Africa were all there as legal realists, or at least sympathizers with legal realism, and represented disciplinary backgrounds in law, anthropology, psychology, sociology, and philosophy. But what does it mean to be a legal realist? What unites the two most famous old legal realisms, American and Scandinavian, with the new legal realism that is invoked variously by sociologists, anthropologists, and political scientists, among others? There are, of course, other legal realisms, old and new, from the free law movement in Germany more than a century ago to the Italian realism of the Genoa school today. My focus, however, shall be on the old and new realisms that are probably most familiar, that is the American and Scandinavian. Is there anything they all share? So let's start with the old, and in particular with an issue that should not be taken for granted in this context, namely whether anything unites the Americans and the Scandinavians. H.L.A. Hart, the great English legal philosopher, certainly convinced a generation of Anglophone philosophers that realism was a united philosophical front against his legal positivism. But it is now common knowledge, I hope, among scholars that Hart misunderstood the American realists. Indeed, even failed to understand that they were in fact tacit legal positivists, committed more or less to his view of the nature of law. It was Hart's mistake to construe the American realist as interested as he was in analyzing the concept of law, that is, the concept implicit in our ordinary talk, about this is what you must do given the court's decision, that reflects the concept of law, or that's impermissible given the statute passed by the legislature. That reflects something about our concept of law. The American realists were, by contrast, mostly interested in understanding why courts decide as they do, not what the ordinary person's understanding of law was. To the extent they presupposed views about the nature of law, as I've argued in other work of mine, they are views much closer to those of legal positivists who believe that norms only count as legal norms in virtue of having the right kind of social source acknowledged by officials in that legal system. For example, enactment by the legislature would be a typical source in virtue of which some norms or rules become legal rules or norms. If Hart's misreading of American legal realism is now more familiar, it is less common knowledge, at least among English-speaking scholars, that Hart probably did badly in his representation of the Scandinavian realists. At a minimum, he was wrong as far as I can see to conflate Alf Ross's views with those of Axel Hagerstrom and Carl Oliver Corona, to name the three major Scandinavian legal realists. And he may have even been wrong in his interpretation of Ross as well. Ross was the one that Hart wrote about most extensively. My hypothesis, on which I'll elaborate shortly, is that American and Scandinavian realism have almost nothing, not nothing, but almost nothing in common. That they are both labeled examples of legal realism is probably a misfortune and accident of intellectual history. While the Scandinavians appear to have adopted the label realism to signal their opposition to metaphysical idealists, that is, philosophers who thought the nature of reality was dependent on the human mind and its categories, the Americans invoked a much more colloquial sense of realism as something like being candid about what really happens, especially when courts decide cases. And this means, right, being candid without any sentimental or moralistic illusion. So a very different sense of realism than the Scandinavians were interested in. Now, that the Scandinavians and Americans should turn out to be so different is hardly surprising if we remember how utterly different in professional background and intellectual interest the Americans and Scandinavians were. The great American realists, Carl Llewellyn, Jerome Frank, Herman Oliphant, Walter Wheeler Cook, Max Radin, Underhill Moore, Thurman Arnold, William O. Douglas, among others, were law professors and lawyers with no philosophical training and rather obviously no aptitude for or interest in philosophical questions. There was one American realist who actually had a PhD in philosophy, a fellow named Felix Cohen. I think it served him badly, but we can talk about that in Q&A. But he's atypical on that score. What most of the American realists were all interested in quite clearly was how courts actually decide cases, and what lawyers and law students needed to know if they were to reliably advise their clients about how they would fare in the courts. The Scandinavians were quite different. They were either primarily philosophers by training, for example, Hagerstrom, or had formal training in philosophy, and all were primarily academics and scholars who conceived of their jurisprudential questions in philosophical terms. In contemporary terminology, they were all occupied with variations on what philosophers call the location problem. That is, the problem of how we locate some phenomenon of interest, say consciousness or moral value. How do we locate this phenomenon in a world that is naturalistically conceived? That is conceived in terms that could be articulated nomically or at least causally by the empirical sciences. In other words, how do we make sense of subjective conscious experience, or of the idea that something is morally wrong, in a world that we take to be exhaustively explained by physics, chemistry, and biology? That's the location problem. How can we locate the experience of Beethoven, or the sense that genocide is a moral abomination, in a world thought to be composed of nothing other than physical, chemical, and biological facts? For the Scandinavian realists, the precise issue was how to locate a legal system of norms. And by norms here, I just mean any statements about what ought to be done, what must be done, and so on. How do we locate a legal system of norms in a world so conceived? None of them were, as far as I can see, attracted to what are called eliminativist solutions to the location problem. Right? An eliminativist solution says if you can't make sense of some phenomenon in a world naturalistically conceived, it doesn't exist. So you ought to just eliminate it, right? So most of us are attracted to eliminativism about leprechauns, with apologies to any leprechaun fans out there. That is, we have no empirical evidence for them. We don't find little pots of gold at the end of rainbows. We don't find little green hats lying about, and so on. So we conclude there really aren't any such things in our world. Scandinavians didn't want to draw the conclusion that legal systems don't exist. So none of the Scandinavians wanted to draw the conclusion that law and legal systems and legal norms did not really exist, just because the idea of obligations or duties and rights did not figure in a natural scientific explanation of the world. Rather, they wanted to find a way of understanding legal norms that was compatible with a semantic, metaphysical, and epistemological picture of the world in which there were no objectively existing values or norms. In other words, if norms about obligations, duties, and rights do not actually refer to things that actually exist, how do we understand the meaning of legal rules that refer to such entities? In this regard, H.L.A. Hart actually has much more in common with Scandinavian realism than his polemic in Chapter 7 of The Concept of Law would suggest, since he accepted a similarly naturalistic picture of the world. The Scandinavian response to the location problem involved a kind of non-cognitivism about the semantics of normative legal judgment, as well as psychologism about norms and normative guidance to deal with the metaphysical and epistemological issues. And let me explain what I mean by that. On the semantic side, having to do with the meaning of judgments about obligations, rights, duties, these judgments were interpreted as expressing certain non-cognitive attitudes or feelings. So a court's judgment of the form, Mr. Smith has a contractual obligation to pay Mr. Jones $5,000 for those widgets, really means, I, the judge, feel very strongly that Mr. Smith should pay Mr. Jones $5,000 for those widgets, and if he doesn't, I will sanction it. The Scandinavian realist psychologism held that legal norms, both their existence and their effects on behavior, were to be explained in terms of the psychological states of people who accepted these norms, rather than the reality of the norms. That X believes, some person believes or feels he has a duty or obligation, is what is explanatory of behavior, not the existence of the duty. We have to appeal to some psychological state of the person, how they feel about a rule, to explain why the rule is effective. A similar kind of psychologism is, I think, implicit in Hart, though he sometimes cannot quite acknowledge it. But it is important to remember that it is central to H.L.A. Hart's view that at the foundation of a legal system, what makes a system of legal norms possible is just a complicated psychological and sociological artifact. Namely, that officials converge on certain criteria of legal validity and believe themselves to have an obligation to apply those criteria. This is Hart's famous idea of a rule of recognition. Hart says, you can't have a legal system without a rule of recognition, a rule that specifies the criteria in virtue of which other rules or norms are legally valid. But he says the rule of recognition is nothing more than what it is the judges actually do. That is, what criteria they treat as legally binding and view themselves as having an obligation to apply in deciding questions of legal validity. Thus, the answer to the question, for example, why constitutionality is a criterion of legal validity in the U.S. is, in the end, on Hart's view, simply that officials of the system treat it as one and believe, for whatever reason, that they ought to do so. In short, I think the Scandinavian realists have far more in common with the great Austrian legal positivist Hans Kelsen and with H.L.A. Hart than they do with the American realists. The latter, that is, the American realists, want to figure out why courts decide as they do and guide lawyers accordingly, while all the former, that is, Kelsen, Hart, and the Scandinavians, are interested in traditional philosophical questions about the metaphysical nature of law and how it can be located within a naturalistic worldview, that is, one that takes for granted that the world is more or less as the sciences describe it. Hart and the Scandinavians differ from Kelsen in their willingness to think the answer can involve naturalizing certain normative concepts in law, that is, understanding them as complicated psychological and sociological artifacts, and thus as part of what Kelsen would have understood to be an impure theory of law. Kelsen thought an empirical theory like that could have nothing to do with the correct understanding of the nature of law. There remains, though, one thin sense in which the Americans and Scandinavians do share something. Namely, they are both skeptical that the legal doctrines the judges invoke in their opinions explain their decisions. Indeed, I shall take this idea, namely skepticism about the causal efficacy of legal doctrine, and I'm going to call it the skeptical doctrine for short. This doctrine is the central thesis of realists in all their many varieties. The Scandinavians, as I read them, actually hold the more far-reaching version of this doctrine, since their skepticism is directed at the idea that an abstract object, like a legal norm or doctrine, can figure in an explanation of behavior without reference to the psychological states of persons. Thus, their skepticism is not confined to the causal efficacy of legal norms, but to all norms. By contrast, the American realist, the Italian realist, the contemporary political scientists who study the judicial process, and many others all subscribe to the more mundane understanding of the skeptical doctrine. The rules and principles the judges recite in their opinions do not reveal the real reasons and motives for their decision, or reveal them only incompletely. It is with respect to what I am now calling the skeptical doctrine that it is often said in the United States that we are all realists now. The anti-realist reaction of the legal process school at Harvard in the 1950s notwithstanding, and we can talk more about that during the Q&A, so notwithstanding legal process, during most of the post-World War II period in the United States, most legal scholars responded with at least some skepticism to the doctrinal rationales given for decisions in contested cases, especially those that commanded the attention of the appellate courts. The triumph of the skeptical doctrine in the United States became clear with the rise of law and economics that began in the 1970s, and the short-lived fad of critical legal studies in the 1970s and 1980s. In the 1970s, Richard Posner, now on the U.S. Court of Appeals for the Seventh Circuit, Posner and then others argued that one could make much better sense of common law doctrines across a range of fields by understanding them as enacting the logic of economic efficiency. One could thus bypass the official doctrine, for example, talk of duty and torts, which economic analysts of law hate, in favor of an economically informed explanation of the patterns of decision. In the 1980s, critical legal studies writers tried to argue that the surface doctrine of the private law was best understood as reflecting political choices between abstract but conflicting political philosophies that were both allegedly implicit in the doctrine. Both these descriptive explanatory programs were ultimately failures, though economic analysis remains the dominant form of normative analysis of legal problems in the United States. But the failure to realize their grand descriptive ambitions coexisted with the continued dominance of widespread commitment to the skeptical doctrine, and in a form that would have been clearly recognizable to the original American realists of the 1920s and 1930s. So let me explain. The American realists sometimes paid homage to the social sciences, even adopting the rhetoric of the then dominant behaviorism in psychology. You know, the classic example, which you may remember from your undergrad psychology course, right? Pavlov's dog. You remember Pavlov's dog? Pavlov showed, right, he would show his dog a piece of red meat. That would be the stimulus. The response would be the dog would salivate, right, in anticipation of having it. Then Pavlov would ring a bell before showing the red meat, and after a while, the dog associated the stimulus of the ringing of the bell with the meat coming, so it would salivate simply when the bell was rung. You didn't even have to show the meat. The dog would start salivating, right? This was stimulus-response psychology and behaviorism at work. So the realists adopt some of this rhetoric. They talk often about the stimulus and the facts of the case. But their actual scholarly practice was largely insulated from the social science of the day. The unfortunate exception being Underhill Moore of the Yale Law School, who squandered his days recording the parking habits of New Haven drivers, and to whom we will return shortly. This did not mean that the realists were not interested in what the courts do in fact. It's just that their approach to the facts about what courts do almost entirely eschewed actual social scientific inquiry, and for good reasons, I think. The paradigmatic realist inquiries of the 1920s, 30s, and after Herman Oliphant on the promise not to compete cases, which I'll come back to in a moment. Carl Llewellyn on the New York sales cases in his book, The Common Law Tradition, but drawing on this work that he had done earlier. Leon Green on proximate cause and tort law, or Milton Handler on trademark. These sort of classic style realist inquiries consisted in careful scrutiny of the underlying facts of lines of cases, bringing out the gap between the official doctrinal explanation for the decision and the actual sotto voce norms of decency and this is Llewellyn, the felt sense of the right result on the facts of the case and situation that seemed to be at work in the judge's thinking. The goal was to discover the non-legal norms that made best sense of the court's response to recurring situation types, as they called them. That is, patterns of fact that seemed to elicit the same kind of results. So, in Oliphant's famous example from an article strikingly titled A Return to Stare Decisis, he denied that there was a single general rule about the enforceability of contractual promises not to compete. Rather, he claims, looking at a long line of cases, courts enforced those promises when made by the seller of a business to the buyer, but found ways not to enforce them when made by a soon-to-be former employee to his employer. In the former scenario, right, that is someone selling a business who promises not to compete with the buyer, Oliphant claimed the courts were simply doing the economically sensible thing. No one would buy a business if the seller could simply open up shop again and compete. While in the latter scenario, that is employees promising not to compete with employers, courts were taking account, says Oliphant, of the prevailing informal norms governing labor relations at the time, which disfavored such promises, especially given the inequality in bargaining power between employees and employers. A meaningful doctrine of stare decisis could be restored on this account by making legal rules more fact-specific, that is, by tailoring them to the underlying situation types to which the courts were sensitive. So too Llewellyn noticed a line of New York cases applying the rule that a buyer who formally states his objections to a seller's shipment, quote, must be held to have waived all other objections. Llewellyn noted that the rule seemed fair in those cases where the buyer ought to have known or did know of the defects he failed to mention, and especially when the buyer's silence has kept the seller from working a permissible and possible cure of the defective tender or has led to unwarranted surprise in the litigation. That's Llewellyn. But Llewellyn also identified what he called a curious pile of cases in which courts normally sensitive to decency announce and apply the rule in its crassest form, that is, without regard to any of the preceding considerations. Like Oliphant on the promise not to compete cases, Llewellyn also found an underlying difference in situation type characteristic of the cases where the rule about formal notice of objection seems harshly applied. Namely, in all those cases, the alleged defect in question does not appear to be the true ground of rejection, but rather the market has turned sour and the buyer is seeking a purely legalistic out. That's Llewellyn's explanation for what's really going on in those cases. In other words, the court being, as Llewellyn puts it, sensitive to commerce or to decency, invoked a harsh rule on rejection in order to frustrate the attempt by buyers to escape contractual obligations that under changed market conditions no longer seemed economically attractive to the buyer. This latter example actually creates a problem for the interesting hypothesis defended by Professor Alan Schwartz of Yale Law School that Llewellyn was really a proto-economic efficiency theorist of contract law. Schwartz notices correctly that since Llewellyn thinks courts generally treat the informal norms of ordinary mercantile practice as the benchmark for their decisions, it would seem that courts generally treat economically efficient norms as the benchmark, given the plausible assumption that those engaged in a particular trade will gravitate towards economically efficient norms governing their dealings. But the example of the New York sales cases makes clear that Llewellyn thinks there is a limit to the neoclassical economist's interpretation of efficiency in this context. For courts do not look favorably on economically efficient breaches, which was precisely what was at issue in those cases. They view such post hoc attempts to escape economically unfavorable contracts as unfair, even if they're welfare enhancing in the economist's sense, and so will not permit them. So contra the economic analysis of contract law, American realists like Llewellyn noticed that courts actually do care about the fairness or unfairness of contractual situation types, at least sometimes. The extreme version of the American realist hypothesis that what really explains appellate court decision-making is sensitivity to the underlying situation type presented by the case is perhaps most vivid in Leon Green's 1931 textbook on torts, which if you're a torts teacher, I encourage you to look at sometime. It's quite remarkable. For it was organized not by the traditional doctrinal categories. That is, there were no chapters on negligence, intentional torts, strict liability. Rather, the chapters were organized by factual scenarios, the situation types in which harms occur. So you had a chapter on surgical operations, a chapter on traffic and transportation, and so on. The premise of this approach was that there was no general law of torts per se, but rather predictable patterns of tort decisions for each recurring situation type that courts encounter. That the preceding examples illustrate the heart of the realist empirical method explains, of course, why the realists were so influential in American law. You did not need social science training to do this kind of analysis. You just needed to be a sensitive and skeptical reader of court opinions, something good lawyers are, in fact, good at. Even my late University of Texas colleague, Charles Allen Wright, lead author of the preeminent treatise on American civil procedure, described himself to me as a legal realist, for he took the task of his great procedure treatise to be the same as Oliphant's approach to the promise not to compete cases. That is, to describe the rules of procedure at a greater level of factual or situation-type specificity, a level that would enable lawyers to accurately predict what the courts will do. Another former Texas colleague of mine, Douglas Laycock, who's now at the University of Virginia, is, among other distinctions, the leading American authority on the law of remedies, though not one who thought of himself as a legal realist, as I discovered. Yet his classic debunking of what American courts call the irreparable injury rule is a case study in realist analysis, as I eventually convinced him. So now he will admit he's a realist. The irreparable injury rule states, courts will not enjoin misconduct when money damages will suffice to compensate the victim. Only when the harm would be irreparable, hence the name of the rule, will courts issue an injunction, according to the rule. Well, Laycock reviewed more than 1,400 cases and concluded, and here I quote from his book, courts do prevent harm when they can. Judicial opinions recite the rule constantly, but do not apply it. When courts reject plaintiff's choice of remedy, there is always some other reason. And the reason has nothing to do with the irreparable injury rule. An intuitive sense of justice has led judges to produce sensible results, but there has been no similar pressure to produce sensible explanations. That's Laycock. So like the old realist, Laycock finds a disjunction between the law and the books, the irreparable injury rule, and the law in action. That is what the courts are really doing when they confront these cases. And also like the realist, he invokes as an explanation for that disjunction the decision maker's, quote, intuitive sense of justice. So too, following in Oliphant's footsteps, Laycock seeks to reformulate and restate the rules governing injunctions to reflect the actual patterns of decisions by the courts following their intuitive sense of justice. So how did the myth arise that the American realists were proto-social scientists, forerunners, say, of the political science work on courts, championed in our day by Frank Cross, Lee Epstein, Jerome Siegel, Harold Spaeth, and Emerson Tiller, among many others? Or inspirations for the law and society interest in qualitative studies of the law in action? Without a doubt, both the political scientists and the law and society scholars benefited from the realist defense of the skeptical doctrine. It opened the door to the idea that to understand how the law really works, it is not enough to know legal doctrine. In that sense, the recent developments are realist in the sense of depending upon the skeptical doctrine. And without a doubt, the American realists share with the social scientists, our contemporary social scientists, the ambition of making the study and understanding of law scientific. But they share that ambition with Christopher Columbus Langdell, inventor of the case method, as well. Let us remember that the idea that only a Wissenschaft, which is the German word typically translated science, the idea that only a Wissenschaft was a proper object of university study, the idea that arose with the birth of the modern university in Germany in the early 19th century, was taken for granted by almost everyone in the Anglophone world in the late 19th and early 20th century. The Anglophone word science, alas, has a connotation of natural science that is entirely absent in the German. The original idea of a Wissenschaft is simply the idea of a method or discipline for acquiring knowledge, a method or discipline that, when correctly followed, secures the reliability of its results. The natural sciences, to be sure, are our preeminent example of successful Wissenschaften, and it was the natural sciences that both Langdell and the American realists had in mind in their own quest to establish law as a Wissenschaft. But whereas Langdell thought the legal reasoning of the courts as expressed in their opinions were the data on which the science of law should be based, the American realists objected that those opinions were more often post hoc rationalizations than illuminating about the actual causal explanation for decision. To really understand the decisions, the American realists noticed, you had to pay attention to the underlying facts of the case, the situation types, as we've seen, and the informal and not fully articulated norms that inform the judge's response to those situation types. That, for the American legal realists, was the essence of a legal Wissenschaft. And a smart realist lawyer could be a practitioner of this Wissenschaft without becoming a social scientist with physics envy. So whence the idea that the American realists wanted to bring social scientific methods to the study of law? That they not only opened the theoretical door for such work, but were advocates, proponents, even practitioners of it. This latter myth, I think, has two primary sources. First, the unfortunate but cautionary tale of Underhill Moore mentioned already, and second, the fact that Llewellyn collaborated with an anthropologist to study the customary practices regulating the social life of the Cheyenne Indians. Let me take both of these up in turn. In my own work, I'm indebted to the legal historian John Henry Schlegel at the State University of New York at Buffalo for introducing me systematically to Underhill's Moore's work in his valuable book, Schlegel's valuable book, on American legal realism and empirical social science. Schlegel adduced the evidence that various American realists expressed curiosity about the social sciences and talked about how the social scientific study of law might be useful and interesting and so on, but he found only one real practitioner, namely Underhill Moore. Moore, alone among his fellow American realists, took the state-of-the-art of contemporary social science seriously. Unfortunately for Moore, the state-of-the-art was Watsonian behaviorism. B.F. Skinner made the behaviorist doctrine famous, but John Watson was the founder, as it were. The psychological behaviorists thought of themselves as bringing the methods of the natural sciences to bear on human beings. And since it was central to natural scientific method that sensory experience is the source of all genuine knowledge, the behaviorists thought it imperative to limit themselves to the only aspects of human psychology available to direct observation, namely what stimuli affect behavior and what behavior results. This was itself a caricature of natural scientific method, but that need not concern us at the moment. What resulted was one of the great travesties in the history of the human sciences. Decades of largely trivial or uninteresting attempts to discover the laws of cause and effect governing observable stimuli and behavioral responses of persons, with the actual content of the mind, beliefs, desires, feelings, all off limits to scientific psychology. Noam Chomsky initiated the destruction of the behaviorist program in the 1950s, and today, of course, what's called the cognitive revolution, the idea that what goes on in the mind, even if not directly observable, is central to an adequate psychological theory, has basically triumphed. Alas, poor Underhill Moore, without any independent critical tools in his intellectual arsenal, took the behaviorist program rather seriously. Other American realists were aware of that program, and as I noted, it showed up in their rhetoric. But only Moore, among all the American realists, thought that a properly scientific study of law, science again being the marker of a mature intellectual discipline, only Moore thought such a scientific study would actually dispense with talk about what judges or people believed or thought. So we're going to explain court decisions without any regard to what the judges think is fair or sensible or economically efficient or whatever. The end point of this trajectory of research was the lead article in the Yale Law Journal of 1943. I invite you to look it up. 100+ pages analyzing the parking practices of New Haven drivers when the parking signs changed. Among Moore's discoveries, when the signs changed, not all drivers noticed right away, but giving tickets helped change their parking habits. Such was the state of art of behavioral legal science in the 1940s. Some 20 years later, with Moore in mind, Carl Llewellyn wrote dismissively in the common law tradition, and I quote, "An appellate judge is not a Pavlov's dog." The failure of Moore's research program should certainly give today's enthusiasts for social scientific approaches to law pause. Moore had undoubtedly tapped into the dominant research paradigm among psychologists, and he was not, as far as I can tell, an inept practitioner of it. But Moore hitched his wagon to a failed research program. Excuse me. And its application to law was even worse than its application to other aspects of human behavior. Might it not turn out that rational choice models of judicial behavior or social psychological results about the behavior of college students prove similarly unilluminating with the benefit of distance and hindsight? Perhaps so, though at least one has some reason to think the cognitive revolution in psychology, to which all the dominant social scientific models of human behavior now subscribe, does seem a genuine advance in the study of human behavior. The crucial point, however, for my purposes, is that Moore was an outlier who, unlike the vast majority of American realists, did not spend most of his time reading court opinions and disentangling doctrinal rationales from factual situation types. Much of social scientific study of judicial behavior that today travels under a realist banner is much closer to Moore than most of American realism, in the sense that it looks for correlations, which it takes to reveal causal relations, between characteristics of the inputs and the outcomes of judicial decisions. Now, very far from Moore's behaviorism was Carl Llewellyn, both in his revolutionary work on commercial law and in his famous study of dispute resolution among the Cheyenne Indians, undertaken jointly with the anthropologist E. Adamson Hoybel. For many years, Llewellyn's and Hoybel's book was the preeminent example of field work in legal anthropology, one that might seem to put the realist imprimatur on the necessity of social science for understanding law. Yet a careful reading of the work by anyone familiar with Llewellyn's jurisprudential views actually belies that impression. The point of the book is quite clearly to show that those who resolved disputes among the Cheyenne had what Llewellyn later came to call situation sense. That is, an ability to perceive the sensible or fair rule both for the case before the decision maker and beyond. In the Cheyenne way, Llewellyn describes situation sense, and here I quote, as the peculiar sureness in the application of felt living institutional norms and peculiar adjustment of the felt rules and the treatment of the particular cases to something bigger and more vital than any rule of an individual case. That's Llewellyn's rather florid prose, which many of you may be familiar with. He also describes it as, quote, utterly clean juristic intuition, individualized yet moving with singular consistency, whither tribal welfare demands that it shall move. The great American jurists, says Llewellyn, did their work well nigh as much by intuition, nearly as much by intuition, as by rational construct and rational development. And the remarkable achievement of the Cheyenne, according to Llewellyn, was that they, quote, produced a large percentage of work on a level of which our rare and greater jurists could be proud, which is all the more notable because explicit law, that is, law clothed in rules, was exceedingly rare among them. Yet the Cheyenne still produced, he says, a, quote, highly predictable consistency in their actual handling of a whole sequence of knotty cases. And that's what the book is mostly about, the examples. All of Llewellyn's other work, that is, besides the work on the Cheyenne, which involved reading cases not visiting Native Americans, is meant to vindicate the role of this kind of situation sense in adjudication. So why did Llewellyn turn to anthropological field work here? There's only one reason, as far as I can see, and it is stated candidly in the preface. It was the only way, Llewellyn says, to study, quote, the law ways among primitive peoples, namely those who do not record their decisions in written opinions. In other words, the one major venture by a leading American realist into actual field work about law and action was necessitated only by the fact that the so-called primitive people he was studying did not have a tradition of written resolution of their disputes. This is an old realist argument for social science in rather special circumstances only. A new legal realism, which many scholars now champion, would continue the paradigm of scholarship established by the old legal realists, namely contrasting what courts say they're doing with what they actually do. We are all realists now because this is what so many legal scholars do, including those who know nothing of social science, like Douglas Laycock, and don't even self-identify as realists, like Richard Posner. None of this is to deny the value of sound empirical work on law and the legal system. Such work might even illuminate the gap between what the courts say they're doing and what they're actually doing. It is only to say that the newer forms of legal realism, though they presuppose the skeptical doctrine of the old legal realism, have rather little to do with the old legal realism of the Americans, which had such a significant impact on American law and legal scholarship, and essentially nothing to do with that of the Scandinavians, which was concerned fundamentally with philosophical questions about where to locate the phenomenon of a system of legal norms in a world naturalistically conceived. It is a testament to the impact of these old realists that so many newcomers, with little in common and often diverse agendas, want to claim their mantle. Thank you.
So we have a good 20 minutes for questions. I'm going to try to take questions from students and guests of the law school first, if anybody feels so inclined, before opening the floor to my colleagues who are always ready for questions. All right, well, I guess I'll let Richard start us off.
Thank you very much, Professor Leiter, for a very thought-provoking presentation. At the very end of your talk, you referred to that all these realisms presume the skeptical doctrine. And one place earlier in your talk, you said that the skeptical doctrine opened the door to the idea that to understand law, how law really works, it is not enough to know legal doctrine. I'm wondering if there couldn't be a reverse causality going on here that would be worth paying some attention to, or an endogeneity, or however you want to call it. That is to say, that becoming external to a legal system, like you use H.L.E. Hart's term, or impure in Kelsen's system, or what is it, phenomenal rather than numinal for Kant, or an under system, moving to the order of events rather than the order of ideas, standing outside makes you not only, as Hart would say, not when you're just describing like a social scientist or like a client counselor, you don't feel the obligations of the law. You don't even can't even use the word obligation. I am obligated. You're just saying this would happen. You are obliged, and therefore you don't the open texture, the slight differences in different parts of the law don't make sense to you anymore because you're not, as a participant, able to make sense of them. Morgan talks about this a bit, how you can take an extreme legal realist like Jerome Frank, put him on the bench, and suddenly, because he's inside, he can make sense of things. So what I'm suggesting is that maybe it's the stepping outside to be a social scientist or to advise a client or to be a revolutionary or for lots of other reasons why one might step outside the law is what generates the skeptical doctrine, rather than it that we suddenly discover, by golly, nothing makes any sense, and therefore we're pushed outside. How can we make sense of the law?
Good, thank you. So, first thing to say is that kind of worry, right, which certainly has a resonance when you read some of the political science literature. Right? So if you read, Jerome Siegel and Harold Spaeth, explaining court decisions and what they call the attitudinal model. Right? Their thesis is the political attitudes of the judges do much better than explaining the decisions they make than the doctrine. And the sense you get very quickly with people like that is they have no idea actually how legal reasoning works. Right? They're just clueless about it. Right? And so there the charge seems warranted. But notice that it's clearly not warranted in the case of the American realists themselves. Right? That is, the American realists hold Jerome Frank aside for a moment because he's another outlier in American legal realism, and I'll explain why in a second. But most of the realists, right, as I said early on, they were very serious lawyers. They were no fools. They actually knew quite a lot about practice. And what they noticed from their own internal experience in the law, right, is that the courts would write decisions citing doctrines that didn't actually seem to explain what was going on. You know? And that's, as it were, what got the whole realist program going, right? That there seemed to be this gap between the recitation of the irreparable injury rule and when the courts were granting injunctions and when they weren't. And that's what gave rise to the sense that there was this gap, that the skeptical doctrine was true. Okay. Now, so they certainly can't be accused of, as it were, stepping outside and so missing something from the internal perspective. Now, it is true that from the internal perspective, the American realists, and again, I'm holding Jerome Frank to one side for a reason I'll explain momentarily, but most of the American realists, the people I'm talking about, Llewellyn and Oliphant, they thought legal reasoning was, in fact, indeterminate, contrary to someone like Ronald Dworkin. Right? They thought that, in fact, when courts found doctrinal rationales to get them to an outcome that they wanted to reach on other grounds, they weren't necessarily doing anything improper. That it was in the nature of common law legal reasoning that there was a sufficient amount of flexibility built in. That you could take any precedent, as Llewellyn famously said, and read it either very strictly or very loosely. You read it strictly when you want it to be controlling, you read it loosely when you want to, you read it strictly when you want to distinguish it. You read it loosely when you want it to be controlling. Where strict and loose means how much factual specificity do you build into your statement of the holding of the earlier case. And Llewellyn and Max Radin thought something similar was true about statutory interpretation. That there were too many canons of statutory construction that courts could avail themselves of, with the result that for any particular statutory provision, they could read it in a couple of different ways depending on what outcome they wanted to reach. So the skeptical doctrine of the American realists is very much internal, I think. Now, some of the social science work on legal decision making, even though it is external, right, that is, it doesn't try to get inside the mind of the legal reasoner, right? You might think it does sometimes produce evidence for something like the skeptical doctrine. So some of the political science work does show, right, rather striking correlations. Well, here's the study Richard Posner likes to cite. And if you're interested in this, I urge you to look at his book, How Judges Think. That was his book 6 books ago, a couple of years ago. But it's actually a very good sort of compilation of an overview of the empirical social science literature. And Posner's great example in there is, turned out political scientists were much better at predicting what the Supreme Court would do in constitutional law cases than were constitutional law professors. That is, the insiders, right, who thought about this in terms of the doctrine did a lousy job. The outsiders who thought about this in terms of political attitudes and so on did a much better job. We could ask why that might be true, but one possibility is that the skeptical doctrine is true. Now, why am I putting Jerome Frank to one side here? Frank was an outlier among American realists, and they all knew it at the time, and Frank was very sensitive and slightly defensive about it. The ironic thing is that the long-term reception of legal realism has been Frankified. So when people say, oh, realists say that, judges just decide for idiosyncratic reasons, it's all about the personality of the judge and so on, that's Frank. That's Frank. Whereas most of the realists, because they were interested in law reform, thought there really were patterns to decision, that it wasn't all about the idiosyncrasy of the judges, that courts in commercial law cases were really sensitive to the informal norms of mercantile practice, and that played a big role in their decisions, which is why Llewellyn then writes it into Article 2 of the Uniform Commercial Code. Right? If you look at the definition of good faith, right, it builds in fair standards of dealing in the trade. So most of the realists didn't share Frank's kind of extreme view. But as they pointed out to Frank, if Frank were right that the individual personality of the judge was the decisive factor in judicial decision-making, lawyers would faced big trouble ever trying to figure out what was going to happen unless they had real insight into the personality of the judge they were coming before. Frank himself was a big believer in Freudian psychoanalysis. He went through decades of it, and he thought all judges should go through psychoanalysis so they understand how their unconscious leads them to respond to the facts and parties before the court. But you're quite right, when he got on the court, when he was on the U.S. Court of Appeals for the Second Circuit, he did change his tune, right? Because this particular view of judicial decision-making doesn't, as it were, seem too helpful if you're a judge who has to actually decide a case, right? No one's going to be happy if you say, I'm sorry, you remind me too much of my father who I wanted to kill, so I'm going to have to decide against you. But what he did on the bench, and there's a wonderful example of this, it's called Ricketts versus Pennsylvania Railroad Company. I think that's it. It's a 1947 opinion. If anyone's interested, I'll send you the citation for it. What he did on the bench, in this case most explicitly, is he adopted something, well, not something, he adopted Oliver Wendell Holmes's view from the path of the law, which is, he said, what we ought to do when we decide cases is explicitly identify the policy concerns that are driving the decision, and we shouldn't get all hung up. You know, this was a case about a railroad employee had been tricked into signing a release after being injured on the job, right? And now they wanted to revoke the release in order to get certain kinds of remedies that were available under federal law. And the question was the release a valid contract? And the majority opinion in this case is by learned hand, and it is a learned hand opinion, a very skillful analysis of objective and subjective views of contract, and, you know, mistake, and all kinds of, you know, subtle doctrinal distinctions. And Frank comes in and says, let's not get hung up on all that stuff, right? Let's just forget all the Williston on contracts. It's irrelevant. He says, let's just talk about the policy issue at stake. The policy issue at stake is who's going to bear the cost of these accidents. Is it going to be the employer, or is it going to be society at large? Right? And in fact, we think that employers should bear it. And he doesn't quite give the Guido Calabrese reason, but it's what he's driving at, which is the reason employers ought to bear the cost is because they're in the best position to avoid the accidents in the first place. And therefore, we should just say that's our policy. So all you employers out there, all you railroad companies, right, you can just forget about trying to get your injured employees to sign these releases. We're never going to enforce them. Okay? That approach hasn't exactly caught on either. Right? I mean, even if you read, you know, Judge Posner's opinions, right, there's a lot of policy thinking going on, but even he's more discreet about it, right, than Frank was in this particular case. But as I say, Frank really is a kind of, you know, a strange outlier within legal realism, and most of the realists, his contemporaries, thought his views were kind of nutty, right? And that it didn't really illuminate what they themselves thought they knew from actual practice, which is you can figure out what the patterns of decision are, you can figure out what sorts of considerations are influencing the courts. You don't need to turn it all over to a Freudian therapist to figure out, you know, what's going on in the unconscious mind of the judge. So sorry, that was kind of a long answer, but I think I...
Thank you.
Yeah.
Yeah, you mentioned Scandinavian realism, but you didn't really go into it, and I'm not all that familiar with it. So I guess since you seem to suggest that the American approach is more sort of pragmatic, very practical, very descriptive, just trying to do a better job of doing it. Does this mean that there's a more prescriptive approach under the Scandinavians, that they're just sort of taking a sort of philosophical set of assumptions and trying to build something off of that?
Okay. So let me say, I don't think the relevant contrast is between descriptive and prescriptive. Okay. I think when you said pragmatic, you were closer to it. On the American side, they really were, as I said, they were all lawyers and law professors. Some of them were never even law professors. William O. Douglas was briefly a law professor, and then in the SEC, and then on the court. Thurman Arnold was the founding partner of the firm now known as Arnold & Porter in Washington, D.C. You know, Llewellyn was a banking law associate at Sherman and Sterling at the start of his career in New York, and of course remained very involved with the law. In that sense, they really did have a very practical interest, which is they thought that if you, I mean, here's how I sometimes sum it up, right? If you only teach students an official doctrine, right, they won't have a clue about what's actually going to happen when cases come before the courts. Right? And so in that sense, they thought this was of great practical importance, not to be misled by very general statements of legal doctrine without regard to how differences in underlying situation types affected what the courts really did. What I'm saying about the Scandinavians is, I mean, first thing was, some of them were trained as lawyers, but they were all academic lawyers. They were all like me. They were all, or they were philosophers, they weren't even lawyers. They were all interested in a distinctive kind of philosophical problem, right? Which is, what is the nature of X? Right? What's the nature of art? What's the nature of the mind? Right? What's the nature of morality? What's the nature of law? Right? What's the nature of law? And in particular, they were interested in this because of a particular set of philosophical assumptions that were prevalent at the time, less prevalent now, right? But it was a kind of severely naturalistic picture of the world, right? And I mean very severely. That is, I mentioned chemistry and biology, but that's already being too generous. Physics, right? You want to know what the world is like? I got news for you. There's no people here, there's no tables, there's no chairs, there's billions of invisible, colorless, odorless particles, right? And now we have a location problem. How do we locate people in a world as described simply by physics? That's where they were coming from. And they were coming at it with the question, here's the law. And the law is full of talk about your obligations, your rights, your duties, what you ought to do, what you must do, right? But physics has nothing to do with your obligations, your rights, your duties, right? So how do we make sense of that? How do we understand that? And this is what led them to, right, certain claims they would make. They said you ought to think of any talk about an obligation as just a prediction, right? To say you have an obligation to pay $5,000 upon delivery of the widgets is simply to say that if you don't pay the $5,000, then the seller may in fact take you to court and get the court to, right, force you to award the $5,000. In other words, get all the normative language out, right? Because normative language doesn't have any place in a naturalistic or physicalistic conception of the world. And in that regard, the Scandinavians are a lot closer to HLA Hart and Hans Kelsen, though Hart in particular wasn't quite as austere in his naturalistic picture of the world as the Scandinavians were. So that's really the contrast I'm trying to get at. Scandinavians were really philosophers, and the Americans were really lawyers, would be a simple way to put it. And the Americans were interested in very lawyerly kinds of problems, which I think is precisely why they were so influential in American law in the 20th century.
So, and you're also an expert in legal education. And
I don't know about that.
At least well known for your blogging about legal education. So I'm wondering about how to apply your lessons about American legal realism to legal education today. And as a legal scholar, I am terrified of the story of Underhill Moore. It terrifies me. I don't think anybody wants that to be their fate, right? If they're a legal scholar. So do we have
law journal, lead article, what's the problem?
Why exactly
I
right.
feel that way.
I guess that's a good point. But
It's paid the bills.
right, whatever, yeah, I mean, you'd be happy, I guess, watching new-age drivers, whatever. But do we have a generation of Underhill Moores who think that they are working in the tradition of American legal realists, and do we need to have a wake-up call and return to the original mission? I'm
Okay.
reading it into what you're saying. I'm not.
I think I understand what you're asking here. I mean, so look, here's the reality of university life and academic research, not just in law but in all disciplines, which is most of what people do and write turns out to be fairly worthless. You know, and all of us hope, right, that against the odds, we're actually onto something. But the reality is, you know, most lines of research don't pan out. Most lines of inquiry turn out not to be worth pursuing, and so on. But I take it the premise of universities is we have no way of telling that in advance. Right? And so we practice the philosophy of let 1,000 flowers bloom. Far be it from me to sit in judgment and announce certain things absolutely aren't worth doing. I'm not in any position to do that. We have to, as it were, the test of time, right? Ideas are put out there. Behaviorism was the dominant research program in American psychology departments for decades. In retrospect, it seems insane. You just say, how could these people think you could explain anything about human behavior and never talk about what people believe, or what they feel, or what they think, or what they desire? I mean, in retrospect, it seems very strange. But, finally, through the Let 1,000 Flowers Bloom, we did get past it. Are we at risk of similar things today? Sure. I mean, as much as I love my colleagues at the University of Chicago Law School, most of them have a false view about human behavior called rational choice theory. But, it's productive in certain domains. They do interesting things with it. And even in its wrongness, as it were, there are things to be learned. I mean, even Richard Posner, as I said, gave up on the economic program of the 1970s. He finally admitted that the descriptive program, to try to re-explain all common law doctrine in terms of economic efficiency, didn't really work that way, right? It was too much of, forcing, what is it, square pegs into round holes, right? Is that right? Round ones into square ones. I forget how it goes. In any case, they don't always fit. So I think that's just part and parcel of university life. The premise of universities is create a space in which people can explore lines of research and hope that over time certain things shake out and we make progress. As I said, I think the cognitive revolution in psychology was actually progress. It should have happened a heck of a lot sooner, right? But it didn't. But we got there, as it were. So will it turn out that a lot of this, what I call the pseudoscience of courts, the Lee Epstein stuff? Yeah, I hope it'll go by the wayside. A lot of it's pretty silly, I think. Wait, is that on video? Sorry.
We'll bleep it out.
Yeah, you bleep that one out. Lee doesn't take time when you haven't told us those kinds of things.
Well, with that, I think we've come to the end of our hour, but the conversation can continue. I think there's a reception out in the atrium, and those of you who have other questions or comments, Professor Leiter, please feel free to